All right, so let's get started. I'm Glenn Cohen. I'm the faculty director of the Petrie-Flom Center, a professor and a deputy dean at Harvard Law School, and it's my pleasure to welcome you today to the webinar's colloquium on abortion and Jewish law. It's being jointly hosted by the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School, and the Julis Rabinowitz Program on Jewish and Israeli Law, also at Harvard Law School. Many thanks to Susan Kahn at the Julis Rabinowitz Program for proposing this event, and of course the team at Petrie-Flom for their work to make this happen. I'm going to start with a couple of housekeeping matters, and there's a slide up that should go over some of those. The first is just to say if you want to submit a question at any time, you should do so using the Q&A feature. That's the Q&A feature found in the meeting controls at the bottom of your screen. You can also join the conversation at X, the artist formerly known as Twitter, at Petrie-Flom. That's at Petrie-Flom on X. We'll share a fully captioned version of this event with all registrants from about 1 to 2 weeks after the event. You can also find additional background reading on today's topic linked at our events page if you want to read more about this. If you encounter a technical issue, you can email petrie-flom@law.harvard.edu. If you're interested in our other upcoming events, news, or education programs, you can use the QR code on our screen to check out our website, subscribe to our newsletter, and also read our blog called Bill of Health. You can also find out more about the Julis Rabinowitz program on the hls.harvard.edu website, and I think it's at pjil.law.harvard.edu. Okay. So I'm going to introduce the speakers. We have them in kind of segments, so I'll introduce them segment by segment, and I'm going to act as the moderator and the timekeeper. We're going to have plenty of time for questions at the end, so please stick around. By way of introduction, in the wake of the U.S. Supreme Court's decision in Dobbs, Jewish plaintiffs in multiple U.S. states have brought religious liberty-based legal challenges to restrictive statewide bans on abortion. Jewish law contains multiple interpretations of when life begins. Today, we gather a range of religious and legal experts to look at the history of Jewish involvement in abortion legal matters, delve into Talmudic understandings of fetal personhood, and consider how all of this plays into the context of the post-Dobbs era and the contemporary Supreme Court's trends on religion and other topics. So let me first introduce our first set of speakers. And because we have many speakers, I'm going to be very brief about how I introduce them. First, we've got Michael Helfand, who's the Brendan Mann Foundation's Chair in Law and Religion at Pepperdine Caruso School of Law, as well as the Florence Rogatz Visiting Professor at Yale Law School. Among his many accomplishments, he also has a forthcoming law review article describing and analyzing shifts over time in amicus brief arguments made in abortion rights cases by a range of Jewish organizations and movements. Sarah Ronis is an associate professor of theology at St. Mary's University. Her next book has the sumptuous title of Fetal Positions, the Talmudic Construction of Personhood, so right on point for today's topic. And it examines how concepts of the fetus appear in ancient Jewish texts. Sarah also published The Thigh of Its Mother, the Fetus and the Subordinated Subject in the Babylonian Talmud. Michal Rauscher is an associate professor of Jewish studies at Rutgers University. Her recent article for The Revealer argues that a Jewish legal approach to abortion is flawed and suggests that Jewish advocates of abortion rights should instead develop a moral and legal framework for reproduction based on the lived experience of Jews who have had abortions. They're each going to talk for 10 minutes, and I'm going to give the floor to them.
Good morning or good afternoon, depending on your location. I'm excited to get things kicked off here, and I just wanted to thank our hosts, both of the institutes, as well as Glenn Cohn, and in addition, Susanna, who reached out to me about this presentation. Today, I'm going to try to very briefly discuss the history of Jewish advocacy for the right to abortion, and not just any advocacy, but as Glenn just mentioned, religious liberty advocacy. For more on this, I have a piece coming out soon, but my attempt today will be to try to summarize the basic points in, well, the 9 minutes I have left. Jewish liberty, religious liberty claims, as Glenn just mentioned, have taken center stage in the wake of Dobbs v. Jackson, Whole Women's Health. To give you an example, here's a quote from legal commentator Eli Mistal just after Dobbs came out. Quote, "The first lawsuit I'd like to see is from a Jewish woman who has access to an abortion provider denied in a Christian theocracy state, sue that the Christian rules inhibit her religious freedom under the Free Exercise Clause of the First Amendment." And one can find plenty of similar types of tweets or commentary on Twitter or X, depending on what you call it. And Jewish law, as these commentaries kind of already express, disrupts the narrative that religious groups, or all religious groups, support. Jewish law is typically understood to focus on the well-being of the mother, broadly construed. It affords a right and even imposes an obligation for abortion where the mother's well-being is at stake. It thereby puts religious liberty and anti-abortionism somewhat at odds. And so we've seen lots of lawsuits asserting the religious liberty rights of Jews against abortion restrictions, including in Florida, Indiana, Kentucky, and others. Not surprisingly, again, scholarly commentary has intensified given this the range of lawsuits. And the scholarly commentary is not just about the merits of the lawsuits, but it's also a debate over whose claims in this context are authentic. Some have accused progressive Jews of being inauthentic in pressing claims of religious liberty against abortion restrictions. Others have accused Orthodox Jews of being inauthentic in aligning themselves with pro-life conservatives. Ultimately, a debate over what advocacy is authentic and who is misusing Jewish law for political purposes has become a common theme and debate within this scholarly literature. But as I read the literature, I noticed nobody was looking at the history, and that got me curious. Is any of this advocacy new? And if not, what can we learn from the story of Jewish religious liberty advocacy for abortion rights? So let me try to start with some Jewish law and religious liberty basics. Everything I'm about to say is both true and false. It will be delved into much more by those addressing these topics directly, but I hope to be able to set the table just a little bit. So here are some Jewish law basics. First, the dominant view within Jewish law is that the fetus is not a person. I said that way too fast. There's going to be a lot of discussion about that for those who want more. Second, Jewish law only authorizes abortion when the mother's well-being is at stake. Third, many, if not most, Jewish law authorities have expanded this consideration to non-physical concerns. And fourth, this right to abortion is in some ways an obligation for abortion, as odd as that may sound. Jewish law envisions an obligation to promote the well-being of the mother, and that potentially includes an abortion that would satisfy such a standard. As a result, a religious liberty claim predicated on Jewish law could be pretty straightforward. Consider, for example, that many abortion laws have a rape exception. Where there are non-religious exemptions, current Supreme Court doctrine also requires religious exemptions. Jewish law in some circumstances requires abortions to protect the well-being of the mother, and therefore, where an abortion restriction with a rape exception prohibits an abortion that is sanctioned by Jewish law, free exercise doctrine would seem to require a religious exemption. Okay, again, everything I just said hopefully sets the table and can be deeply problematized and contested in a variety of ways. But it hopefully does enough to give you a sense of how Jewish law and religious liberty law seem to fit together to create a natural religious liberty claim. And this has entered public and academic discourse relatively recently, but in fact, because of this natural fit, Jewish groups have actually been making these sorts of arguments for over 30 years, and they follow three basic paths. The first has been advanced by Agudath Israel, a traditional Orthodox, some might even refer to them as ultra-Orthodox, such an umbrella Jewish group. And since 1989, they've actually been advancing religious liberty claims in the context of abortion. The first such brief, amicus brief, filed before the Supreme Court was in Webster v. Reproductive Health Services, again in 1989. They filed a similar amicus brief in 1992 in Planned Parenthood v. Casey. And here's what the brief in sum argued. Agudath Israel welcomed reconsideration of Roe, and they said, quote, Jewish tradition accords fetal life significant protection. It rejects the notion that termination of pregnancy, even prior to fetal viability, is a matter of free choice within the province of the mother. But the brief also addressed Jewish law's demand to allow abortion to protect the well-being of the mother. Quote, any reconsideration of Roe v. Wade carries with it the danger that abortions might be legislatively prescribed even when they are mandated by religious belief, under Sinaitic Jewish law, for example, where the mother's life is endangered. And so the brief crafted an argument that did just that. Quote, what is called for in the Good of Israel of America's view is a jurisprudential framework that is at once protective of human fetal life, yet solicitous of religious freedom. Post-Dobbs, A Good of Israel has maintained this view, issuing a press release tracking this argument after the decision was announced. But interestingly, A Good of Israel has stopped filing amicus briefs supporting these sorts of arguments. It has not intervened in the religious liberty lawsuits, for example, against abortion restrictions. By contrast, progressive Jewish groups have also used religious liberty, but on the opposite side of the political spectrum. These briefs also start in 1989, those using religious liberty, although their advocacy goes much further back. But with Webster in 1989, those briefs started focusing on religious liberty directly. And they were explicit in aiming to upset the narrative that religious groups opposed the right to abortion. Quote, within the Jewish tradition, there is considerable agreement that the fetus is not a person before birth, and that abortion therefore is not murder, and may be permitted and indeed required in situations where the life of the mother is threatened. And in turn, the brief argued, quote, Missouri cannot claim that the Free Exercise Clause guarantees only people's freedom to hold pro-choice views, but not their freedom to obtain an abortion in any public facility. You see similar briefs like this filed by this collection of progressive Jewish groups in subsequent cases, but they presented a little bit of a puzzle. If this was a religious liberty claim, shouldn't that mean that Jewish claimants, based on Jewish law, should get religious exemptions, while the abortion restriction itself remained in place? In contrast, these briefs argued actually to strike down the entirety of the abortion restriction. Here's what the brief in Webster explained. Quote, any process providing for exemptions would be insufficient protection of religious freedom, given the intrusion any process for considering exemptions would itself place on the individuals facing intimate decisions involving procreation and termination of pregnancy. And such a process of evaluating claims for exemption inevitably, according to these organizations, would run afoul of the Establishment Clause's entanglement prohibitions. Quote, this court's rulings on the dangers of government entanglement with religion would apply in any case-by-case evaluation of religious beliefs about abortion. What's interesting is post-Dobbs, many of these organizations have supported the aforementioned lawsuits seeking religious exemptions. To do so, they've implicitly jettisoned these Establishment Clause worries. Of course, as advocates, use the law as is available to you. But this is a change in strategy, and one can see why it is so attractive. In the world of Roe, it made little sense to press for religious exemptions. But in the world of Dobbs, religious exemptions provide something quite powerful. And in turn, the advocacy has changed to meet this new reality. A third and surprising alternative is the advocacy of the Orthodox Union, and I see I have 1 minute left, which is the largest umbrella organization of American Orthodoxy. Summarized quickly, in contrast to other areas of advocacy, the Orthodox Union has actually not filed any amicus briefs with respect to abortion, arguing in various other kinds of documents, quote, we cannot endorse a public policy that does not reflect the complex response of halacha to the abortion issue, and, quote, after Dobbs issuing a press release, we are unable to either mourn or celebrate the U.S. Supreme Court's overturning of Roe v. Wade. And one can see, given this ambivalence, neither side of the litigation providing an argument that really captured their underlying views, why the Orthodox Union has resisted filing on the side of one or the other. What might we learn from this advocacy? Let me make 3 quick points. First, there has been remarkable consistency about the broad structure of Jewish law across decades and across denominations. 2, the strategies have changed over time. While in the late 80s and early 90s, A Good of Israel pressed for exemptions and progressive Jewish groups pressed against exemptions, the roles have now flipped. And third, the story really is about, ultimately, the challenge a religious minority faces when their religious commitments don't quite match up with either side of a litigation. In the winner-takes-all stakes of litigation, with ever-changing legal doctrines at play, the stories of Jewish law advocacy for abortion rights presents the ultimate Goldilocks problem. It's hard to get that advocacy just right, and maybe with that, I'll stop.
Thank you very much, Professor. Now we'll go on to our next speaker.
Good afternoon, everyone. Good morning. Thank you to the organizers and to all of you who are joining us today. As the only scholar of ancient Judaism on the panel, I want to use my time today to complicate our association of abortion and Jewish law at all, particularly in our reading of ancient texts. My work is on the Babylonian Talmud in the context of late antiquity. And by late antiquity here, I mean the 2nd through 7th centuries CE. And we have extensive evidence from the late antique world that there were numerous ways to end an unwanted pregnancy. And we have extensive evidence from Christian and Zoroastrian religious and legal texts and from Roman civil law that many jurists, theologians, and ritual experts thought seriously about the legality of abortion and its implication for a wide range of legal spheres. In late antiquity, then, abortion was widely discussed, theologized, criminalized, and legally permitted, sometimes in the same text. But abortion is not a serious topic of conversation for the rabbis of the Babylonian Talmud. There are maybe, and I'm putting a big question mark on maybe, 2 mentions of intentionally ending a pregnancy in the Babylonian Talmud. One, Bavli Yevamot 69b, discussing Mishnah Yevamot 7.5, presents it entirely neutrally. And the other, Bavli Sanhedrin 57b, is a theoretical discussion of legal differences between Jewish and non-Jewish law. In neither case does the single offhand mention turn into a larger discussion of the phenomenon. And yet the rabbis talk about fetuses all the time in the context of ritual purity and impurity, inheritance law, laws about who can eat what kinds of sacred tithing, epistemology, and discussions of the sale of animals and enslaved people. So the rabbis clearly care a lot about the fetus and fetal personhood, but they actually don't seem to care about abortion. To paraphrase Gwyn Kessler, abortion discourse has colonized a reading of ancient texts. Ethicists, religious authorities, and political activists read texts like the Talmud to find principles and analogies that could work to speak to major issues in today's world. But that doesn't mean that that's what those texts were originally about. And while I want to be clear that within the internal rules, both of legal precedent, from a civil law perspective and from the perspective of Jewish law, or halacha, doing that kind of creative work is absolutely legitimate and valid. But it doesn't erase the fact that the rabbis of the Talmud were doing their own really interesting thinking with the fetus. And for those of us who want to understand the rabbis of the Talmud, and to be honest, the kinds of creative legal thinking of the medieval and modern scholars who use the Talmud for analogical thinking, there has to be space to ask what we can learn from reading the Talmud's discussions of fetal personhood on their own terms. Let me give you 2 very brief, but also very complicated examples. The first example is the title of my article that was mentioned, "The Fetus is the Thigh of Its Mother." Now, this is a principle that takes on resonances of bodily dependency and subordination and focuses on the body and agency of the pregnant person. And yet in the article that I shared with the panelists, I note that in the Talmud, this principle is used very selectively because the rabbis actually only apply this principle to the bodies of pregnant animals and enslaved people. They discuss and reject its application for the bodies of free Jewish women. Indeed, reading this principle in its Talmudic context demonstrates its original use as a way to legally and ontologically distinguish between the pregnant bodies of the free and the unfree, subordinating certain gendered and sexed bodies by ascribing difference to their very limbs and organs. And as I wrote within the article, I'm doing that thing where I quote myself now, quote, "The rabbi's discourse demonstrates that for this one self-described elite group in late antique Babylonia, one's status as human was contested, relational, and tied to one's autonomy within the economic and legal system. It was also profoundly embodied, written onto and into the bodies of all involved," end quote. So that's "the fetus is the thigh of its mother." Let me turn to the second example. And this is a famous phrase. It's even shown up on Samantha Bee. "For the first 40 days, the fetus is mere water." This one comes up a lot in responses to abortion bans that are rooted in particular weeks of pregnancy. Now, the phrase appears only once in the Talmud, in Bavli Yevamot 69b, in its discussion of an extraordinarily specific case. And a word of background. According to Leviticus, the unmarried daughter of a priest, if she has no children with a non-priest, is entitled to eat of the sacred tithes, truma and maser, as a member of the priestly household. Let me say that again. The unmarried daughter of a priest who has no children can eat the food of her father's household. The Talmud asks, what happens if this unmarried daughter is sexually assaulted by a non-priest? Now, from the perspective of the Talmud, and let me just say we can and should have our own reactions to this, if she becomes pregnant, she is now forbidden to eat the sacred tithes because the fetus interrupts that right. But what is she to do in the period between the assault and when she learns whether or not she is pregnant? The Talmud quotes Reb Chisda, who offers the winning answer. Quote, she immerses and eats up to 40 days. For if she is not pregnant, then she is not pregnant. And if she is pregnant, for the first 40 days, the fetus is mere water. End quote. Note that the question is a really specific one related to a particular, and I would argue particularly abhorrent case. But it's a question about at what stage a fetus interrupts a person's affiliation with a priestly household. In this case, the Talmud insists that the fetus has the ability to affect their environment, to condition particular ways of living for both the pregnant person and their enslaved property. At the same time, the Talmud resists constructing the fetus as the subject and agent of the process. Is personhood even the right category to use to understand how the Talmud is constructing the fetus? So then what do we do with all of this? Rather than making normative claims about the fetus, I would argue that rabbinic discourse rejects the idea that the fetus could be made a coherent and consistent signifier at all. Ultimately, my work demonstrates that the very instability of the category of fetus and its personhood, both across time and place and within a single religious community at a specific moment. The question isn't, is the fetus a person in the Talmud? It's what kinds of person is the fetus in the Talmud, and how much do those distinctions matter? The rabbis think with the fetus in many different ways. This diversity highlights the rabbis' own debate and disagreement over the fetus, and emphasizes the continuous, and I would suggest continuing, interplays between tradition, legal and literary contexts, and cultural contexts. But before I conclude, I want to note one other thing. The rabbis of late antiquity, analogous to rabbis and Jewish legal thinkers today, operated on one register. That in no way means that all Jews, then or now, operate on the same register. We have a wide range of evidence for a diversity of Jewish meaning-making and ethical thinking in the ancient world, some of which is both explicitly Jewish and unrelated to rabbinic discourse. In thinking about the rabbis' approach, then, I want to name that my work focuses in on this one group to offer one set of possibilities. And these are thought-provoking, rich possibilities, but they were not then, and are certainly not now, the only possible ways to think about fetal personhood, or quite frankly, anything. Thank you.
Thank you very much. We'll now hear our last of the initial speakers.
Hi, everybody. Thank you for having me. I'm really looking forward to our conversation together. It's great to be here. I am a scholar of contemporary Judaism, and in particular, Jewish reproductive practices. One of my main interests in my scholarship relates to the intersection of religious authority and reproductive ethics. So in my comments today, I will be focusing on how liberal Jews and Jewish groups use rabbinic texts, Jewish legal texts, to construct an approach to abortion. You've heard already from Michael Helfand of the history of this kind of advocacy. Like Sarah Ronis, I have reservations about claiming Jewish support for abortion by referencing ancient legal texts. My reservations differ from hers, but they're not in opposition, I don't think. Before I go on, though, I just want to mark the passing of Rabbi Barry Silver. Rabbi Silver was one of the leaders of the legal cases brought before his state of Florida, opposing abortion restrictions on the grounds of religious freedom. His loss is a significant one for the movement. I want to say that I understand the appeal of using these Jewish texts in abortion advocacy. Biblical and rabbinic citations are a marker of official or legitimate Jewishness in a multi-faith public sphere that often relies on religious texts to mark similarities and differences among traditions. Texts are also recognized as ancient, timeless sources of authorities. Such texts can be appealing sources for activists in the context of legal briefs and policy statements, bolstering their authentically Jewish stances. But I maintain there are three problems with this approach. The first is that ancient rabbinic texts do not value reproductive agency, the very principle that liberal Jewish pro-choice advocates seek to promote. Rabbinic sources promote a justification approach to abortion. The rabbis who made these rulings, as well as those who have written more recent rulings that draw on these sources, determined the circumstances under which women were permitted to terminate their pregnancies. These opinions start from the assumption that abortion is wrong, but can be permitted or sometimes required when religious authorities, but not individual women, deem it justified. We see this in practice in Rabbi Broid's article, which he will, I'm sure, talk about in a few moments, in which he advocates for abortion only after people have spoken to their religious or moral authorities. We have also seen a similar justification framework in the US since at least the 19th century. Today, this approach is ubiquitous. It starts from the assumption that abortion is morally wrong, but can be permitted or justified in circumstances like rape, incest, or maternal health. Abortion bans with exceptions are legal enactments of the justification approach. Jewish advocates of abortion rights need a clear, supportive statement of reproductive agency. They aren't getting that from the texts they're citing. The second problem with the textual approach to pro-choice Jewish advocacy is that just 9% of American Jews identify with Orthodox Judaism, yet activists advocating for reproductive justice are limiting Judaism to the sources and patriarchal authority structure of orthodoxy. Liberal branches of Judaism, conservative, reform, and reconstructionist, for example, have defined themselves in varying relationships to Jewish law, but most American Jews do not believe that observing Jewish law is an essential part of their Jewish identity. Therefore, a Jewish legal approach to reproduction does not represent the religious lives of most American Jews. Approaching the moral permissibility of abortion from the perspective of Jewish law is a violation of the unique philosophies and theologies of each of these liberal religious movements. Now, perhaps the most important reason why the current Jewish reproductive justice approach is flawed is that Jewish law does not determine Jews' reproductive decisions in the way that some of this advocacy might suggest. Focusing just on abortion, we know that 79% of Jews in America believe abortion should be legal in all or most cases. This means that the vast majority of Jews believe people can and should make their own moral decisions about abortion without limits. That's not the rabbinic approach. When we broaden our view beyond a narrow focus on abortion, a much more complex picture of the relationship between texts, rabbinical authority, and reproductive views emerges. In my own research on Jewish reproductive practices and ethics, I have repeatedly found that Jews of all denominations and no denomination do not rely solely, if at all, on rabbinic law for their reproductive decisions. If they do turn to rabbis, they turn to their chosen rabbinic authorities with whom they have a relationship for guidance and support. Moreover, I found that women and others who can become pregnant make decisions about reproduction within the context of their lives. Choosing if, when, and with whom to have a child is one of the most consequential decisions in an individual's life. When Jews are deciding whether to get pregnant and whether to continue a pregnancy, they're not thinking about it as an abstract moral question to be answered by Jewish texts. Instead, they're thinking about how a pregnancy will affect their health, their work, their goals. They're debating whether a child will impede their ability to take care of their current children or complete their education. I contend that we need to think about abortion as one reproductive experience among many. Furthermore, we need to see reproductive decisions as integrated into Jewish life and experience. In this way, reproductive decisions, including abortion, are an expression of Jewish identity. So I have two examples from my research that demonstrate, excuse me, that abortion is consistent with Jewish reproductive values and practices. When I spoke to Haredi, ultra-Orthodox Jewish women in Jerusalem, as research for my first book on reproductive ethics, they told me again and again that their rabbi's opinion, itself a distillation of Jewish law, is irrelevant. Instead, these women, mothers to 5, 6, 7 children and more, felt that they had the authority to make reproductive decisions based on the fact that they were the ones who were pregnant. They claimed this religious authority over their bodies within a dense web of familial and religious relationships. The Haredi women I spoke to held a deep sense of connection and obligation to their existing children, their extended family, their community, and to themselves, all people under their care. These obligations motivated their decisions to use birth control, to get pregnant, to give birth in a certain hospital, and to have an abortion. Likewise, American Jewish women of all types of religious affiliation have been making decisions about abortions without turning to a rabbinic authority. For the last 8 months, I have been collecting abortion stories with several co-investigators from Jews who terminated pregnancies in the United States since 1973. Surveys with over 200 participants and interviews with more than 100 of them reveal that the vast majority of participants did not consult with a rabbi or any other religious figure before having an abortion. Some did and found rabbis supportive of their decisions regardless of circumstance. Some found community that helped them after terminating wanted pregnancies. The majority of our participants had an abortion because it wasn't the right time for a child. This is consistent with national research on why U.S. women have abortions. Many of those in our study were using contraception when they conceived and were grateful for the opportunity to terminate because it meant that they could continue on the trajectory they set for themselves. Women have shared that their families and their communities expected them to finish school, get a job, get married, and when ready, have children. This is also consistent with national research about people who have abortions. In these narratives, we learn that Jews see abortions as part of their life story and a morally right decision that they made based on their own priorities and abilities. In fact, many see their abortion as that which allowed their life to happen the way that it did. Jews who share their abortion experiences with me and my research team are part of a growing movement that encourages people to talk about their abortions. In fact, there are several published narratives from Jews who, over the last decade or more, had abortions. In these narratives, they tell of Jewish prayers they recited or rituals they performed to mark the Jewish significance of their abortions. These experiences are proof of Jewish women supporting abortion. This, too, is Jewish support for abortion. The current fight for abortion rights is not just about the right to reproductive health care. The fight for abortion rights has also become a battle for liberal religions to be recognized as religions in the public square. Conservative religious beliefs about abortion continue to limit reproductive agency and to deny the moral good of abortion. Jewish advocates for reproductive justice in America have an opportunity to push back against these claims in order to strongly support reproductive justice for all and to uphold a pluralistic public square. Liberal Jewish groups should stop relying on rabbinic authority and instead trust women to make reproductive decisions about their lives. Thank you.
Thank you so much. We now have time for 2 5-minute respondents. First, we're going to hear from Rabbi Michael Freud, who's a professor of law at Emory University School of Law. His writing is focused on what Jewish law thinks secular abortion law ought to be. We're then going to hear from Rabbi Jonathan Zaslow, who's a professor of law at UCLA School of Law, whose writings is focused on Jewish ethics and particularly issues concerning civil disobedience. And he's also preparing a commentary on Pirkei Avot, the core of rabbinic Judaism's view of the ethical life. But first, Professor and Rabbi, the mother must be very proud, Freud.
Thank you very much. It's a pleasure to be here. Thank you very much to the organizers. Most of my work focuses on modern Jewish law in its many different permutations. When Roe was struck down, I stopped to write an article on what did I think Jewish law thought secular law should be in the area of abortion, which is not the same as what does Jewish law think abortion law should be. What abortion law should be, I think, is a matter of a grave fundamental dispute, with one school of thought thinking that abortion is essentially about the taking of the life of the fetus. Another is that abortion is essentially about taking the life of the fetus only after viability. And another is about abortion never being the taking of a life, and the fetus is not a life at all. But I think that the question of what does Jewish law think American abortion law should be, or secular abortion law should be, is a totally different question. The central issue in Roe and Dobbs is federalism important? Who decides? Is certainly not an issue that the Jewish tradition cares a whit about. I think the Jewish tradition views secular abortion law as grounded in 4 ideas. First of all, the Jewish tradition doesn't really think that it's our mission to have a secular legal system that's deeply moral. The second is sometimes it's a good idea to push that morality, but it's not always. And abortion is one of those cases where pushing morality doesn't seem to be fully consistent with what the Jewish tradition wants, because the Jewish tradition recognizes that abortion is a very individualized decision, and there's a central obligation of the right of people to make their own decisions in consultation with their own religious advisors. And in that model, I think the Jewish tradition recognizes a great deal of personal choice. It recognizes the right of people to ask their own religious authority what they ought to do and then implement it. And lurking in the background of that is the Jewish American experience, particularly felt in the Orthodox community, that giving the government a toehold in religion, even when we might agree with what the government does, eventually the government expands its role and starts legislating in a variety of ways. And we ought to be more structurally libertarian, to keep the government out of a variety of areas that we want autonomy in, even in the area of abortion. Our main concern as Jews, even in abortion, is our ability to practice our religion freely. There is no right to abortion in Jewish law, but there are cases, such as when the mother's life is in danger, when an abortion is mandatory. And there are other cases, depending on the stage of pregnancy and the medical or psychological issues in question, when a Jewish law authority, in consultation with a woman, or maybe a woman in consultation with a Jewish law authority, might think that an abortion is proper and recommended. And I think we want to maintain our religious liberty to implement such lenient rulings in every case and in every situation. And because of that, I think that the Jewish tradition is nuanced, complex, and a secular law has a hard time being nuanced and complex. And thus, I think, given the choices, the Jewish tradition would like a secular legal rule that's permissive rather than prohibitive in nature. It recognizes the rights of every person to make their own decisions in these matters. And I don't think this is unique to abortion. I think, by the way, this is how the Jewish tradition would handle a variety of personal ethical decisions from beginning of life on to end of life, rather than unique to the abortion situation. we favor legislation in these areas that permit personal autonomy and permit people to consult their religious authorities as they see fit. The Aguda position that Michael Helfand made such mention of is essentially that approach, even though it's not couched that way. It says everybody should be permitted to have an abortion after they tell you. They asked their religious authority, and their religious authority told them they should have an abortion. That's a liberal rather than a conservative position. Thank you all very much, and thank you again, the wonderful organizers of this conference. Thank you.
Thank you, Rabbi. And now over to Rabbi Zaslav.
Well, thank you. I usually think of myself more as Professor Zaslav of MBA. I should be speaking more as Rabbi Zaslav. I want to thank everybody for inviting me here. Interesting question that is raised by the papers here. If I think about this in terms of a commentator, one of the big questions is you can distinguish between legal centralism and legal pluralism. Legal centralism believes that law is top down. In the secular sense, law is handed down by the state. In the Jewish sense, law is handed down by Hashem, by God. In the first passage of Pirkei Avot, it says, Moses received Torah at Sinai, and he passed it to Joshua, and Joshua to the elders and the prophets and the men of the great assembly. Legal pluralism says, no, that's not the way that law works. Law actually bubbles up from different communities and is not handed down by a particular lawgiver on this one. Well, what does Jewish law say? In my interpretation, to some extent, you could argue that Jewish law is a legal pluralist system that pretends that is a legal centralist system. So there are many circumstances in which it says, well, obviously this is what Torah says or what God says, and we're simply following it. But there are a lot of circumstances where in both classical and more modern Jewish texts, things change, and that it's simply a matter of different communities and different groups. There are even positions in the Talmud that talk about how, well, the rabbis really wanted to do this, but the public wouldn't let them do it. And so there's more of a legal pluralist way of looking at these things. And I think that in the three papers that we're looking at today, we can see sort of the spectrum of opinion here. Michael Helfand, by speaking about what Jewish law says, is thinking about it more in a legal centralist way. There is a law, it has been handed down, there is a way of negotiating it, but there is a body of law there that we have to follow. Although, again, since I'm moving fast, Michael, I apologize for oversimplifying your position. Michal Raucher is I think it is fair to say, a radical pluralist. The law is not handed down. The law does bubble up from the lived experience of individual people. Sarah Ronis is somewhere in the middle concerning all of this, in the sense that the rabbis are arguing different questions. They promote the questions, they promote the structure of this, but there's a lot of play in the joints. And of course, she has to have a great deal of credit for having gone through the tractate of Yevamot, which is one of the most mind-numbing sections of the entire Talmud. So what do we do with all of this? What we see is, in one sense, that Jewish law has been and is in the constant process of radically changing these different balances between centralism and pluralism. Professor Chaim Simon of Villanova has been doing some extremely interesting work and very important work about how Orthodox Batei Dinim, who have been empowered by arbitration law in the United States, have been essentially generating new forms of law in different places that could conceivably look very different in many places. A major sociologist of Judaism said about 10 years ago, there will be Judaism in 100 years, but it will look completely different from what it looks like now. And that is very, very true. Also of the Orthodox community, which is constantly changing, which is constantly adopting things, which is radically transforming itself while pretending that it is not. It has now adopted a very right-wing positions on a whole series of political issues that 30 years ago it would not have. Professor Joshua Shanes of the College of Charleston has been doing some extremely important work on that. 150 years ago, the notion of ultra-orthodoxy did not exist. So this balance between centralism and pluralism is going to be constantly changing. And I think that to some extent, this offers a challenge to both Orthodox and liberal, or what we might say heterodox wings of the Jewish community. The Orthodox, I think, if they want to be able to be more true to the tradition, have to be less dogmatic, insisting that this is what Jewish law says. In fact, it is a much more plastic and pluralist tradition than they argue. And I would also argue that perhaps the liberal Jewish places might want to be more dogmatic, that it cannot simply be a matter like in the last line of the book of Judges, that there was no king in Israel and everyone did as he pleased. The model here, in one sense, is Talmudic, but the model of Talmudic discourse, not of Talmudic orders. There is in the Talmud the notion of a machloket b'shem shamayim, a dispute in the cause of heaven. That is the dispute that needs to happen within the Jewish community. The two sides need to talk to each other and argue out the position instead of simply rejecting the positions of the other side. Thank you.
Thank you, Rabbi and Professor. Okay, now we're going to shift to our last speaker, then we'll get to the Q&A, I promise, but you're going to want to stay for this one, which is to say we've got the great Elizabeth Reiner Platt, who's the director of the Law and Rights and Religion Project at Columbia Law School, to speak. And then please don't ignore the Q&A because we'll be drawing our questions from there, among questions from me as well. Go ahead.
Great. Thank you so much to the organizers, to my fellow panelists, to our audience. I thought I'd start by saying that the question of a religious right to abortion raises a lot of issues that are well outside my area of expertise. I leave to the rabbis and the other experts in Jewish law the question of Jewish law's approach, or perhaps, as we've heard, multiple approaches or lack of approaches even to the question of abortion. I leave to religious studies scholars, really difficult questions like whether U.S. law's highly individualistic approach to religious belief and practice is kind of an inherently Protestant way of understanding religion in the first instance. These are all very, I think, interesting and important questions, but they have very little to do with American religion law doctrine as it stands today. Our judiciary system is entirely unable, both normatively and legally, to rule on what Jewish law requires. And this is a good thing. We don't want a religious court system in this country. For myself, I can say I certainly don't want this Supreme Court acting as a religious court. And what that all means as a practical matter is that for the purpose of making a religious liberty claim, it really doesn't matter what Jewish law says. The example I sometimes give is that someone comes to court making the legal argument that because of their sincerely held Jewish beliefs, they need to eat a ham and cheese sandwich every day. The court really can't, or at least shouldn't, question that. They can evaluate whether or not you are sincere in the beliefs that you have articulated, but what they can't do is say that your religious beliefs are incorrect or misguided or not real Judaism. So for the purpose of the legal claims that are being brought by Jewish women arguing for a religious liberty right to abortion, the discourse and the question of what Jewish law requires with regard to abortion are just not determinative or even really relevant to those court cases. What matters is what the individual Jews who are bringing these cases understand to be their own religious beliefs, requirements, and practices. I do think it's quite telling that we often don't seem to expect plaintiffs like Jack Phillips, the Christian baker who was unable to design a wedding cake for a same-sex couple, to justify his religious beliefs through very detailed biblical interpretation or the sort of moral authority or blessing, so to speak, of some sort of religious authority. I think the tendency to focus so much on halakha when talking about Jews and abortion is, obviously different to due in part to the differences between how Protestantism and Judaism work. But I do think another part of that difference is that religious minorities, and especially I would say progressive religious minorities, often feel this need to justify their beliefs as authentic and worthy of legal protection, rather than simply assuming, as I think many majority religious groups do, that their beliefs should be considered legitimate, even if there might be a whole variety of beliefs or many co-religionists that disagree with them. And in fact, I would say the irony is, as I think Professor Raucher has suggested, is that when Jews who wouldn't normally turn to halacha for guidance in making their life decisions, then reference Jewish law as a part of litigation, it could actually have the impact of making them seem less rather than more sincere. So if formal religious authority is not required in making a religious exemption claim, what is? Well, we're talking about a very complicated multi-step test, but I'm going to focus on two preliminary showings that a claimant must make: religiosity and sincerity. So one, a claimant has to show that their belief is religious rather than, say, political or philosophical, although again, how we differentiate between these things can be, who knows, really. But again, this is not about whether that belief is correct according to formal doctrine, but rather whether the belief is religious at all. Courts have historically, and I think appropriately, used a very light touch when determining whether a particular belief is religious. There have been a few recent cases actually where federal prosecutors have tried to argue, particularly with criminal defendants, that an asserted religious belief, religious liberty defense rather, was trying to use religion as a fig leaf for views that were in fact, according to the DOJ, political. So, for example, the government argued that the true motivation of a faith-based nonprofit that was trying to open a safe injection center for people who use drugs, it was, quote, socio-political or philosophical, not religious, and that's not protected by religious freedom laws. In another case, DOJ prosecutors argued that a protest held by a group of Catholic lay people at a nuclear military facility where the lay people prayed and poured out vials of their own blood was, quote, an effort to propagandize and obtain secular public policy revisions tinged with post hoc religious justifications, quote unquote. That was, again, the DOJ's argument. In neither case, however, did the court take up the government's argument that the claimant's belief were political rather than religious. A few examples of belief systems that various courts have over the years determined to be not religious include the Church of the Flying Spaghetti Monster, Ayn Rand objectivism, the Church of Marijuana, creativity, which is a white supremacist ideology, and the belief system that required one plaintiff to eat cozy kitten cat food at work. More seriously, there have been, in my opinion, examples of courts unfairly labeling some beliefs to be non-religious, especially those of incarcerated people. But I think the chances of any court holding that essentially any form of Judaism, no matter how idiosyncratic, to be not a religion, I think the chances of that are essentially zero. If a court wants to dismiss a religious right to abortion case, there are many other ways to do so that would be far less contentious. Two, a plaintiff must show that their belief is sincerely held. While courts are somewhat more open to, I think, challenging and looking into sincerity, again, especially for incarcerated claimants, this is also a part of the test that courts more often than not ignore. Recently, as Professor Helfand mentioned, there have been some attempts to challenge the sincerity of litigants in religious right to abortion cases. For instance, in a law review article, 3 members of the Jewish Coalition for Religious Liberty strongly implied that such litigants are using religion claims strategically rather than sincerely. They warn, quote, a litigant whose entire set of religious beliefs happens to coincide with her stated legal positions should raise red flags. And more pointedly, they state that, quote, some women may adopt these religious beliefs in an opportunistic fashion. I address these arguments more fully in an article that will be published this spring, but I will just say that none of the claimants in any current religious right to abortion case claim that abortion rights represent the entirety of their Jewish identity or beliefs. Rather, they describe their views on abortion as part of a holistic Jewish identity that also includes the observance of Shabbat and other holidays, personal prayer, membership in a temple, adherence to a kosher style diet, etc. In addition to the more general ways in which the claimants explained that their, quote, religious beliefs impact and inform much of their lived experiences, including regular lifestyles, moral and ethical decision-making, and family life. Moreover, again, as Professor Raucher, I think, nicely explained, abortion is often indivisible from broader beliefs about life and death, family building, and the duties that we owe each other. I hesitate generally to reach the tea leaves, but again, I would be surprised if any religious right to abortion case was decided based on a finding that a Jewish claimant is insincere, as opposed to deciding these matters through a drier legal issues such as standing, it just feels very unlikely to me as a legal realist that a court would want to make headlines with an opinion claiming that the Jewish women seeking a religious right to abortion are acting duplicitously. I will end by zooming out a little bit to encourage our audience to take a critical approach to the term religious liberty as it's currently used by politicians, lawyers, judges, and journalists. Religious liberty is an extremely malleable term. It means many, many different things to many different people. And religious liberty rhetoric or religious liberty talk has been harnessed in service of political projects of all different kinds. We often see these issues framed as conflicts between a right to religious liberty on the one hand and some sort of secular right, in this case, reproductive rights, on the other. The reality, as we can see from all of the different talks on this panel, is much more complicated, really, with both religious and secular interests on both or all sides of almost every issue. There are many legal and political issues in which actors who hold very different beliefs each claim to be fighting for religious liberty. Thus, I think a more helpful question when reading about these very high impact cases is not whether religious liberty should prevail in a given conflict, but religious liberty for whom and what version of religious liberty are we talking about? So I will stop there and look forward to questions. Thanks.
Thank you so much. And I should also mention that well worth a read is the project memo, A Religious Right to Abortion, Legal History and Analysis, that Elizabeth's project has done, which has influenced a bunch of the RFRA lawsuits against abortion bans and other religious liberty issues post-Dobbs. Okay, so I'm going to start with a question from the Q&A or a variation on it. Then I might ask one of my own and go back and forth. And again, we invite more people to submit questions on the Q&A. And I guess the question that I want to focus on is a little bit about what's distinctive about Judaism here. So one way of putting this is to say there are religious disagreements in all religions, right? And there is a spectrum. And by the way, I'll invite all the panelists to turn on their video as well. Jonathan, we want to see the Shana Punham, as my grandmother would say. Essentially, there are disagreements between in religions always, right? What is distinctive about Judaism in this respect, and also distinctive about the ways in which the courts have treated Judaism, or in terms of what they've asked Jewish plaintiffs to show? Or is there anything distinctive, and this is just religious liberty litigation like any other? So anybody who wants to jump in, feel free to unmute. We might get a few people to answer that one.
So I'll start with this one because as someone who co-authored an amicus brief in Indiana, this is a really complicated question, because I think from the perspective of religious studies and from really understanding the complexity of the category of religion, and Liz, I just want to echo, I think our entire understanding of religion in America is shaped by a white Protestantism that has flattened what that means to all kinds of groups. So, I would say when it comes to religious studies, the answer is, what is distinct about Judaism? Perhaps nothing. That is not the answer that the lawyers we were working with wanted. And so I think we can think about how we want to articulate what it means to be a minority religious tradition, and a minority religious tradition with a long and fraught history with the majority. A 2,000-year long and fraught history with the religious majority. And at the same time, I think we should not let that legal discussion tell us what Judaism is, right? And by us here, I mean both scholars and I mean members of Jewish community who ultimately get to define their own religious tradition rather than, a court in Indiana with only Christian judges on it.
Anybody else want to jump in on this one?
I guess I'll just add, to what Sarah was saying, a lot of the cases that have been brought on religious freedom grounds are combining both Jewish advocates as well as those from other religious traditions. So for sure, the one from Florida, I think the one in Indiana also, Liz, if I'm correct, perhaps the others. So they are finding each other and realizing that there has been a definition of religion floating around that is anti-abortion, which we can attribute almost directly to the creation of the moral majority in the late 70s, early 80s, in which they framed all of American religion as anti-abortion. And so all of these other groups are fighting against that larger narrative framing. And I don't like the direct answer. I'll agree with Sarah. I don't think there's anything distinct about Judaism, but it is about other religious traditions saying that religion is not defined universally as anti-abortion. Even within Christianity, we know there's a lot of diversity of opinions around abortion. The pro-choice Catholics are very loud, and they actually represent a majority of Catholics. So we have a lot of work to do in terms of diversifying the narrative that we have about religion and abortion in this country. Jews advocating are just one piece of that puzzle.
Great. I think Jonathan raised his hand. I think also Michael Broyd has unmuted. So I'll let Jonathan go first. And Michael, if you want to jump in, go ahead.
Yeah, the one unique thing I think about Judaism is actually not a religious aspect, and it's not even a legal aspect. It is kind of a political aspect, but I think that it actually matters for a large part of the very politicized judiciary that we have now. I mean, if it ever wasn't. And that is, in a weird way, for large segments of the right, Jews are sort of honorary Christians. And because that as a minority religion, we're sort of seen as, at least certain aspects of Judaism is almost seen as kind of more real or more legitimate. So, you'll hear all this talk about the Judeo-Christian tradition. Barney Frank famously said, I never met anybody who considers himself to be a Judeo-Christian. But it might have some more purchase with certain jurists, even though that has nothing to do with the religious aspect of it and shouldn't have anything to do with the legal aspect of it. But it could mean something on that. And Sarah, a very fair point about Messianic Jews, but even without that, I think that it could be useful, or it could be important in terms of persuading different jurists of different things.
I think that the American experience in the 50s and 60s and the 70s was heavily colored by life under communist Russia, with its heavy regulation in the name of religion. And even the Jewish law authorities who came here, who you might consider conservative in many different ways, were very pro-religious liberty. And this impacted even matters like abortion and end-of-life decisions, which touch on weighty matters close to murder.
Thank you, Michael. Okay, I'm going to ask a question of my own now. And this was touched on a little bit, Jonathan, by your last comment and some of the other comments more implicitly, which is the relationship between this debate and realignments about Jews' place in the political order and the American political order at the particular moment. Of course, since from when we started planning this, a lot has happened in American politics and Israeli politics, and a realignment in some ways too, in terms of all this. Do you view the questions here and the posturing and the positioning of Jewish opinions on abortion as an inherently part of a political process? And if so, say a little bit more about how you're feeling about that, right? So I'll just open that up, kind of an open question, but the intersection between this debate and American politics, I'm very curious for your views. Go ahead, Jonathan.
I don't want to take up all the oxygen here. I'm 58 years old. Ever since I could vote, I've been hearing about how American Jews are realigning. It so far hasn't happened yet. I think it is true, although I mentioned this earlier, the work that Joshua Shanes is doing is that the Orthodox community has become significantly more conservative. But I don't know whether this is, I think people who are Jewish of whatever denomination or whatever degree of observance are going to, they're not going to let, they're going to be more, it's going to be more about their particular community and what they think, as opposed to their reading of a particular Jewish text on this. What we are seeing is a very strong connection between Orthodox Jews and evangelicals. I find it incredibly interesting to see on social media that Mayor Soloveitchik, for example, is now teaching an online course in reading the Bible. Usually Orthodox Jews would not teach classes on the Bible. They would teach classes on Tanakh, or they'd teach classes on Torah. And it seems to me quite clear that that's an attempt to bring in more evangelicals and unify that. But I don't think it's gonna change certainly things like voting behavior.
Anybody else want to jump in on this one?
I think
Sarah, go
one thing
ahead.
that I think one thing that I would note is that this is inherently political, but that's not a dismissive statement, which is that people are political and people are religious. And as I point out to my students all the time, we don't turn off our religious brains when we walk into the voting booth. From within the sort of normative Jewish perspective of orthodoxy, halacha is political and responding to the political movement and questions that arise in a given moment. And so to say that something is political doesn't mean it's not religious in a way that I think is important. Now, I will also just say, perhaps to build on what Jonathan just noted, Jews have always been political. So I don't know whether, I don't think we can point to a substantial shift in Jews' interest in politics. And I'm thinking here about Melissa Clapper's book on banners, babies, and ballots, or those three in some order, right? Talking about women's political advocacy in the 1910s and 1920s. And so, yes, it is political. Yes, it is religious, because those two things don't pull in separate directions all the time.
Great. We had a question from one of the people in the Q&A about whether Reconstructionist Judaism has a position on these issues or has stepped into debates on these questions. I don't know if anybody feels confident to speak to that.
To the extent that the questioner is asking about kind of official religious positions, yes, they have a resolution from the 1980s that I'm aware of. They have also, they made a recent statement, as did many denominations of American Judaism, when the Dobbs decision was leaked in 2022. So yes, they have positions. Depending on how closely you read it, you might see a reference, a kind of back of the brain reference to some of the texts that have been mentioned, but they aren't as explicit as they were in reform movement statements and conservative movement, especially, and Orthodox, of course.
Go ahead, Michael.
Maybe I'll just add that some of the briefs that I mentioned, the amicus briefs of a collection of progressive Jewish groups, included the Federation of Reconstructionist Congregations. So to the extent that's sufficiently representative, they joined those amicus briefs in the late 80s and early 90s.
Thank you. Okay, I'm going to ask another question. So you all are deep experts on this issue. Most of the people who've covered it have been neophytes or have gotten things wrong. If you had a message that you wanted people who are going to cover, sometimes we have members of the media listening in right now, in terms of what you think people have misunderstood or have approached with not enough nuance in kind of this issue, is there something that crystallizes for you that you'd love to kind of set the record straight, as it were? Rare to have so much shyness among law professors in particular. Michal, go ahead.
Oh, sorry. Michael had also unmuted, but I'll okay, since you said I'll go first. Okay. Yes, I think very basically, and this really shouldn't be something that people get wrong or misunderstand, but I feel the need to say it, which is Jews have abortions. Orthodox Jews have abortions, ultra-Orthodox Jews have abortions, Reform, conservative, non-affiliate, everybody has abortions, and they have abortions for all sorts of reasons. There's a pushback in the abortion research community to talk about talking about reasons, because we should have a blanket understanding that all reasons are good reasons. but that doesn't exist. So I want to, in other words, that assumption isn't there among everybody. So I want to point out that people have abortions, Jews have abortions for all sorts of reasons. It's obvious, maybe, but it's really, really important to point out. I think we have a kind of almost purity culture in Jewish discourse of this topic, where we don't even acknowledge that there are Jews who have abortions because they weren't using birth control, or their birth control failed, or they found themselves pregnant when they didn't want to be. And these sorts of things happen all the time. So that is my very important thing that I want everybody to know.
I think it's important to distinguish between what Jewish law wants its adherents to do religiously and what Jewish law wants coercive secular law to be. And that sharing that central distinction impacts how you perceive religious legal thinking in many different areas, from abortion to so many other areas. Jewish law wants things from its adherents that it's not prepared to coerce from its adherents, never mind coerce from its non-adherents. It also has some things that it thinks nobody should do, that it recognizes that the police should be called when people attempt to do it, like infanticide, which is the killing of an already born child. The Jewish tradition thinks is not a religious matter, but is a criminal matter, and people should be stopped from killing their already born children by use of the police force.
Sure, I would say, not to keep banging the same drum, but I think I would just say the claimants making these cases do not have to show that their understanding of religious beliefs is correct, is the right one, is backed up by, we don't need to go to Talmud. It's just not necessary. And that's not how these claims, we see them being made in other contexts, and by other religious adherents or in less political issues.
I want to pick up on what Michael said, which is that Jewish law wants things of its adherents. And I want to just add, and different communities' Jewish law and different individuals' Jewish laws want things from their adherents that might be different. And then I will just add one more thing, and this is something that I think everybody in this webinar knows, but for those of us who teach undergraduates or in broader community settings, I really wish people knew that the Establishment Clause didn't mean that there was a separation between church and state in this country, or what that meant. I think many of my students really think that means something which it does not mean and are shocked to understand what it does mean. So broader legal literacy for our students and for the next generation of people who are thinking about these issues, I think is a really important piece of this puzzle.
You'll get very little argument about that from this group. All right. So, but in the hopes of provoking a little bit of a broigus between you, is there something you've heard that you strongly disagree with today, right? Or a place where you're like, my learned friend, right over here says something very interesting, but I want to push back on this. So just offering you an opportunity to kind of identify not only the places where you agree, but the places where you think you disagree. Professor Helfand, I think I saw you at that unmute, so go ahead.
Well, I was really hoping to answer the last question. I'll do both at the same time. How's that? So I don't think I disagreed with anything that Liz said, but you know, one of the things that I think the kind of Jewish law using the Talmud in this litigation, I think it's you know, more kind of pressing on, you know, religious minorities, I think, all the time before courts have to explain. And it's not so unique that Judaism is doing this. When I think of like the Santeria claims in the early 90s, how much description there is in front of the courts, Native American claims in the late 80s, which were typically unsuccessful. I think it's less about Judaism and more about, and I don't think she disagreed with this, and more about just minority faith communities having to explain more about what their faiths require. I think that's one piece of it. There's this other piece that, you know, just strikes me as complicated. And I wonder if this is in part what motivates some of the claimants in these religious liberty cases, which is it can't just be that you have a sincere religious belief that your religion permits you to do something. So like I'm an Orthodox Jew. Judaism allows me to eat chicken. I can't say that I make a religious liberty claim that I am permitted to eat chicken. That wouldn't work. It's also not the case that it has to be required. So it's something in between those two. And this is where things get a little complicated. And I'm glad that Liz just raised her hand to say something about this. So it has to be a sincerely held religious belief that there's religious value, I would say, something along those lines, to the religious conduct in question. And here we're talking about abortion. And I think that's in part why you get some of the thick description in some of these cases, because it can't just be that Judaism allows abortion. It has to be something more than that. And I think the thick descriptions help provide analysis to support those kinds of claims. Oh, one last thing in terms of just things I would love people to know. These religious liberty claims are not even remotely new, and oddly enough, they used to be advanced by, let's call them the more politically conservative side of the Jewish spectrum and rejected by the progressive side. And now, like a lot of religious liberty things, we've seen a flip.
Elizabeth, you wanted to speak. Go ahead.
Sure. Yeah, I absolutely agree that it has to, that this has to be more than allowed and less than required. And the way I usually frame it is religiously motivated. This is a religiously motivated decision. One's faith is a piece of the puzzle when looking at what's the right decision for you and your family. And, one case I think of in showing this, you think of a case like Kennedy v. Bremerton. Was he religiously mandated to pray exactly at this place and time? No, of course not. But it was a religious practice. It was clearly a religious practice. It was clearly not something where he said, he heard God telling him that in the middle of the football field at this time he had to pray. So I think that's one kind of way to think about it is this is people, all decisions about, there's really no way to separate one's religious faith from one's decision on this issue. And so, and then I will also just flag, there's also been like some kind of disputes in legal scholarship about how to frame this in the case of people who are not yet pregnant. And I don't want to take up too much time, so I'll just plug myself. I have an article talking about that particular issue that's going to come out this spring. Sorry to do that, but I thought I would mention it.
We've got a couple of people. Michael, go ahead.
I think that Michael Helfand's comment and Liz's response, Liz Reiner-Platt's response, is very important. In a religion like Judaism with notions of good deeds, mitzvot, figuring out when the government can restrict your access to a good deed, to the proper way to live your life, even when it's not religiously mandatory, is going to percolate up very much. In 1920, Professor Louis Ginsburg wrote a famous Jewish law letter about whether Jews should use grape juice for Kiddush in the middle of Prohibition, or should they adopt the government's license to have somewhat sacramental wine. And he started a literature on when should we seek a government exemption to do what the Jewish tradition thinks is ideal, rather than adopt a minimally acceptable alternative. This is an important area to think about in terms of our relationship with the law.
Jonathan, I think I saw you on mute. Go ahead.
Yeah, I want to, well, I don't want to say push back, or my kippah fell off, which is probably a sign. But the push back or complexify or investigate a little bit more Michal's notion about we shouldn't be relying on text, we should be relying on lived experience. What worries me about that is the notion that, Judaism is what Jews do, right? On the other hand, I'm not sure that's fully right, because it couldn't be that one could say, well, if all Jews decided to worship an idol, that one could then say that that was Judaism. As a rabbi, I have a bit of a problem with that. So I'm wondering, how far do you take your pluralist notion here? And if this is getting us too far afield from American law, I don't know. I mean, I think we all know that if it's, again, harping on this centralism thing, it can't just be, well, a few rabbis said it and that's Judaism. That's wrong historically. But it also can't be, well, there was no king in Israel, everybody did as he pleased, and that's Judaism. So on what basis do you say that are there limits, are there parameters to lived experience of Judaism? And doesn't that pose the danger of essentially disintegrating the religion to begin with? And you're smiling, which means I imagine you've been used to answering this question. So I'm now giving you the opportunity to answer
it. Thanks, Jonathan. The first thing I'll say is if you could find all Jews to agree on anything, then I think we could end everything. I mean, all Jews won't agree no matter what. So the idea that all Jews will agree and then will change Jewish practice radically to go with idolatry is, a fantasy, I guess. But I mean, I would say that, so first of all, I'm an anthropologist of religion, which means that the way that I study religion is through lived experience. So my contention about what religion is defined by what people do and how they experience and how they interpret. Now, anthropologists of religion aren't the only ones who think about religion as a lived experience, though. There are those who look at the construction of rabbinic texts and the construction of rabbinic authority also as lived experience and therefore socially constructed. So there is no, even the rabbis, if you can get them all to agree on something, are not somehow outside of the social construction of religion. They're also participating in it. So that's, I mean, I don't know if I fully answered that question yet.
It's a multi-volume treatise, so
right.
Fair.
Right. So, but that's where I would start, that there are no limits, but it's not like I'm saying there are no limits. There have never been any limits to what people define as their religious practice. The rabbis were also engaged in that project. They still are. I imagine that the idea makes you uncomfortable as a rabbi because you've been propped up as somebody who is supposed to have authority over others. And
nobody gives me authority over anybody, so that's
right.
fair enough.
It is troubling. I get the most pushback from rabbis about lived experience among Jews, but it is the way that we define. It is the way that religion functions, is constructed, is studied widely across the academy. I see there are some comments. Can I just throw something else out there that maybe we'll get time
and I'll
for?
just let people know we have about 4 minutes left, so I'll just throw out one more question. You can either continue this thread or add to the other thread, so it's both are good, but let me just throw out the last question, which is to say, we know there's litigation. How do you think it's going to go? And if you could tell judges to read one thing, or trying to think about what to do in these cases, is there something you would advise judges to read, which would also help all of us who are court watchers? But that thread, the disagreement thread, the social construction thread, all open. We'll give everybody one last comment. Michael, you go ahead. Michal, you finish your thought first, and then we'll go to Michael.
Okay, my thought was unrelated. So I'll do what I want judges to read. And that is the transcripts of my interviews with Jews who've had abortions. That's it.
Excellent. So I see you're pointing that way, but that doesn't mean it's going to the same box to me, but I'll go for Elizabeth next. Elizabeth, you go first.
Yeah, I'll be brief. I mentioned I'm sort of a legal realist, so I think these claims will prevail in courts that are amenable to the right to abortion generally, and I think they'll fail in courts that are not amenable to a right to abortion generally.
And as someone well-read, what would you want people to read in thinking about this or better understanding this debate? Is there anything that comes to mind? Other than your work, of course.
Sorry?
Other than your work, of course.
You know what? I'll plug David Schraub's article on liberal Jews and abortion, I believe it's called, and it really goes deep into the religious obligation not to have or not have an abortion per se, but the religious obligation to make a decision about your reproductive life in a way that I think is very interesting and persuasive.
Thank you very much. So we'll get Jonathan, we'll get Sarah, and we'll get the other Michael in, and then we'll go finish with the Michael Health end. Okay, go ahead, Jonathan.
I think in terms of just predicting how the litigation will go, if it goes to the Supreme Court, it will go the direction that the six justices in the majority think would do the most to enhance the political prospects of the Republican Party, which is essentially the way that they operate now. If there has to be a way in something that they should read, it's good histories of Roosevelt's court packing plan to see how there will be pushback.
I see. We love it. Sarah, you go ahead next.
So I'm going to say two things. First, I think perhaps rather than saying judges should read something, perhaps judges should talk to people and actually talk to people who have abortions or advocate for abortions or are opposed to abortions and really, maybe get out of the chambers and talk to people. I also just want to note, I'm noticing this really interesting diversity on this panel that I did want to just respond to the last question, which is one of the things that was so exciting about this panel was the really rich range of perspectives. We have rabbis who are invested in making normative claims. As Michal noted, we have a scholar of we have an anthropologist. I'm a religious studies scholar doing really descriptive work, analytical descriptive work. And so I just want to name that those are two different projects. And they're both really exciting projects. They both, they relate to each other really profoundly. But I just want to make sure that we all, as we are sort of planning what we do next today, understand that there are multiple projects represented by this panel. And I think that we have to make sure that we understand them as different because they're all really important in very different ways. I think they're all important, but I want us to make sure we understand we're not the same or they're not the same. And that was it for me.
Thank you. Michael Broyd and then Michael Helfand. Michael Broyd first.
I think Sarah's comment is what I would tell the judges to read, which is a normative description about what Jewish law tells its adherents has nothing to do with what American law should do. I have nothing to contribute to the American law debate. Pay no attention to me.
First time any law professor said that in a very long time. Michael Helfand, you go next.
So I'm not a legal realist. I believe that there's something to legal doctrine, and we have better and worse applications of it. And I also, notwithstanding not people on this call, but what some of my friends do, already criticizing the court before it's issued the opinion that they're criticizing is something that I just don't do. As I joke, I wait for my kid not to clean his room before I yell at him. So, what do I think is going to happen? I always think that we're going to get a good and fair application of the legal doctrine, and it is my hope, I think, that a straightforward application of the legal doctrine in a case where we've cleaned up complicated issues of standing, and we have a thick but not too thick description of what the religious obligations or motivations are in a particular case. In the right jurisdiction with the right kinds of other secular exemptions could generate, even from the Supreme Court, a protection of religious liberty claims in the context of abortion restrictions. When I say these things out loud, most people think I'm off my rocker. But I do think that a nice, clean, in the right case application of the law just generates that kind of outcome. And I think there's a decent chance we'll get there if we get the right case.
Well, thank you all. And just again, thank you so much for being here today. Thank you to Susan Kahn. Thank you to Susanna Baruch. Thank you to the team at Petrie-Flom. This has been a wonderful, wonderful event, and we'll be making it available to the world to see. So those of you who are with us today, we thank you for spending your time, but we'll have the video up shortly. Thank you all again. Bye-bye.
Thank you for a wonderful program.